Még nem indult be. Okay, dear colleagues, good morning. This is half of our panel. This is the Hungarian side, but I hope that technically we can add us to the Polish side in the afternoon, perhaps. I don't know. But as we are here, let's start discussing our issues. So I open seminar 2 for our research group on freedom of conscience in an institutional aspect. Please note that our discussion is recorded and will be available at the website of the service provider. No, service providers are us, of the principal. So I kindly ask you to present your ongoing research of freedom of conscience, what you have previously done, and what your new conclusions are. So first, I kindly ask Adam to present his views. Adam, the floor is yours. You are still mute, Adam. Unmute. You should unmute, Adam. Just click that microphone. Yes, now it's working.
Okay. Thank you. Okay. Thank you very much. So for today, my topic is freedom of conscience for public employees. I'm going to speak about contemporary problems from international aspects. And next time, I will concentrate on the specific features of the Hungarian situation. So my first question is that how should we define conscientious objection practiced by public employees, especially within public administration? In the context of public administration, civil servants and subjects of other types of legal relationships engage in acts of conscientious objection when they first refuse to provide legal and professionally accepted services that fall within the scope of their professional competence, and secondly, justify their refusal by claiming that it's an act of conscience or it is conscience-based, at least. Within the international literature, some have disagreed as to whether these objection rights must be based on personal objections or whether objections can be asserted as to professional values and norms as well. Thought, conscience, and religion are first of all internal convictions, and it means that it can be interpreted in terms of constitutional law or administrative law only when they are expressed. So freedom of expression is an external expression of a broader fundamental freedom of belief. That's the reason behind the fact that today I'm mainly speaking about theories and practical problems closely connected with freedom of expression and not exclusively about those of freedom of conscience. The main question for ethics, law, theology, and other social sciences is whether it's possible, and if so, then how, to honor individual integrity and moral beliefs without harming those with different beliefs and values. And if it comes to the public administration, that is, to the civil or public servants' conscientious objection, then it becomes more complicated. So, what differentiates these conscientious objections practiced by civil servants from similar conduct in other types of employment relationships. In both the public administration and the wider public sector, there are specific circumstances that distinguish these employees from the average workers. First of all, the presence of official secrets, even state secrets. There are also political appointees within the administration's staff. In some cases, beyond an expectation of loyalty, there is also an expectation of patriotism. Moreover, in some cases, the employee is even obliged to risk his or her own life. For example, in the armed forces or law enforcement authorities. Moreover, the public employees or employee does not represent itself or a company, but the state as a whole, which creates additional responsibilities and risk. And requirements such as integrity, probity, impartiality, or fairness are not, or only to a limited extent, reflected in the business world. So all these facts are serious differences. And all these circumstances significantly limit the possibility and scope of expressing one's own worldview or viewpoint within a certain administrative organ. My next point is, what are the main contemporary approaches to the problem? Based on the review of the scientific literature, what are the main legal and practical aspects of the given issue? First, we see the need for defining the expression employee engagement within public administration. As Kahn a few years ago defined, employee engagement is the harnessing of organization members' self to their work roles. In engagement, people employ and express themselves physically, cognitively, and emotionally during role performances. So the question is, what is loyalty, engagement, and what are its limits? Secondly, in most cases, the balance is tipped in favor of the employee's freedom of expression in one direction and the so-called duty of loyalty in the other. The question is whether, and if so, to what extent the former can be restricted in order to fulfill the latter. On the one hand, it's problematic and can cause serious disadvantages for the employer if the employee shares negative opinions about the employment relationship, and more specifically about the employer on Facebook or on other social media platforms. On the other hand, it may also be a matter of concern if the employee, although not related to the employment relationship, publishes objectionable postings which may be capable of undermining indirectly the trust in the employee. Thirdly, the most frequent question, or one of the most frequent questions, is prohibition of coercion that leads to division within the employee, within his or her own conscience. What are the most regular, most common, most frequent cases or case types there? For example, the first one is compulsory oath for civil servants. The second one could be participation in abortion, provision of other medical treatments. Third one would be participation of health professionals or teachers in political protest and or in civil disobedience. The fourth possibility is vaccination, earlier related to vaccines made using human cells, more recently in cases of the COVID-19 vaccine. The next possible type or case type is closely connected with those topics of same-sex civil marriages and other gender topics. For example, the question of whether a province can require civil marriage commissioners to perform same-sex marriages over their religious objections or over their non-religion objections as well, has been addressed by the Canadian courts in a series of cases. In each of these cases, the issue is framed by the courts as a contest between religious freedom or even non-religious beliefs and sexual orientation equality that must be resolved through the balancing of these competing interests. And each of these cases, the court strikes the balance in favor of sexual orientation equality, determining that the equality rights of same-sex couples outweighs the religious freedom of marriage commissioners. Fourthly, the nature and intensity of conscience issues may also depend on the type of public service system. For example, Finland and Bulgaria are two very distant countries in terms of public service principles and their actual application. For Finland, the core values are independence, impartiality, objectivity, trustworthiness of government, transparency, accountability, and responsibility. For Bulgaria, we see similar concepts as well, but there are also such values as loyalty, stability, hierarchical subordination, and these are more prominent. So independence versus hierarchical subordination suggests that while Finland focuses on public service, Bulgaria is more drawn to the given government, and this may obviously have an impact on the conflicts of conscience that arise. Fifthly, there are not only officials of a particular state, but also of international organizations. And within the scientific literature, we can see that conflicts of conscience may arise in balancing the interests of the international organization represented and the sending state with the expectation of the home government and in enforcement of political considerations. My sixth point here is a question: to what extent can an employment contract or collective agreement restrict the freedom of choice? And the last one here is that there is an ongoing debate on the protection. The public administrations should give to non-religious claims of conscience compared with religious claims of conscience. And there are some possible reasons why some administrations give greater protection to religious claims of conscience within their practices. First, tradition favors religious claims of conscience, and what's more important, governments are less competent to deny religious claims of conscience than non-religious claims. So we have arrived to my third point. In what new alternative ways are legal systems and public administrations trying to address these phenomena mentioned previously? First of all, there are some new institutional answers that have been given to make the treatment of conscience issues more transparent to society, to the society as a whole. For example, in January 2018, the Trump administration established the Conscience and Religious Freedom Division within the Department of Health and Human Services Office of Civil Rights, with the explicit goal of intensifying legal protection of religious and conscience objections in healthcare. Secondly, more effective protection of whistleblowers is also a new goal, connected to some extent with my topic. Whistleblowers are vital for maintaining an open and transparent society, as they expose misconduct or hidden threats to ensure that they are better protected against negative consequences. EU directive on the protection of whistleblowers came into force in 2019, and Hungary also tries to implement it recently. There are also steps and measures to reduce the pressure and intensity of conscience-related issues in a given sphere, for example, within healthcare or the educational system. It means that nowadays not only companies, I mean business companies, but also states or governments acting as employers recognize the importance of establishing a work environment where differences are treated with respect and inclusion. Diversity, equity, and inclusion programs, including employee training, should include religious and non-religious differences. It is the responsibility of both the employer and the employee to be aware, knowledgeable, and respectful of a wide range of religious and non-religious beliefs. Fourthly, a new direction is the assessment, clarification, and weighing of the consequences and damages caused by the conscientious objections, even on a scientific basis. What are the certain harms of accommodating refusals to duties? The first direct harm of accommodating refusals to fulfill legal or professional duties is hindering an individual's ability to exercise a right to obtain a legal service or good. But there are also indirect harms as well. For example, exempting professionals from duties may undermine trust and respect for the profession or even for the public administration as a whole. Moreover, objection might increase the workload of those willing to provide services, as they pick up the slack from those who refuse. And there could be several further aspects as well. And lastly, development of tests to determine whether a belief-based claim can be justified or not is also a new and important direction. Not so new, but important direction. For example, one of those tests is used by the European Court of Human Rights in some cases, or has been already used in some cases. And within that test, the first question is how well-founded, serious, coherent, or even relevant, important the belief is. It's important that its truthfulness, its objective validity is irrelevant. Only the coherency is important for the court. The second step within that test is we have to ask about or do questions about the existence of a logical connection between the belief and a certain breach of the law, whether there is a logical link or connection between those two. And the third question is whether the person who claims that his or her beliefs must be taken into account takes seriously his or her beliefs, or it's only a bad excuse from him or her. Thank you very much for your attention.
Thank you very much. It was really interesting. Now there's just three of us. Is it possible to have questions now, or should we discuss everything after? What do you think?
Maybe after.
Maybe after. Okay, then Balázs, the floor is yours.
Thank you. Exceptionally, I'm trying to share.
Then you need me because I can make you a presenter. Just a second.
Then I make you a presenting.
So
just to
okay, sorry, I need to.
I can also put it in the chat board.
Oh, it's also with us. Just a second.
For you to see the text or to see some elements of the text.
Sorry, I made Adam attendee, so now I can make Balázs presenter. And as I see, Zdzislav is also with us. Do you hear and see us? We don't. Anyway, Balázs, the floor is yours. Now you can share your screen.
Is it? So I click enable screen sharing.
Yes. And then teljes képernyő.
Full screen.
Full screen, and then just click the full screen, and then you can share.
Screen, and then click the full screen. Yeah, that's what I'm doing.
Full screen. There's a screen on your monitor.
There's just a screen on my monitor, yes.
And now you can share.
And now I can share. Yes, I could share.
You have already shared it.
Sorry?
You have already shared it. It works.
Well, I don't see what I'm sharing.
It says that you are sharing your screen.
I'm sharing my screen. Yes.
Yes, no. There were your slides, but now they are gone. Yes, now they are.
But in that case, I don't see you, and that's a loss. Anyway,
we see your slides.
Yeah, wonderful. One of our problems we face with conscious rights, that it's very hard to define what conscience is and what are the possible claims one could have on the basis of his or her conscience. And the second step would be if we can have if conscious rights that are very individual, conscience by its nature is very, very individual, whether that can have a normative, an institutional aspect, the protection of the rights of conscience. And here I may need a little explanation on the document I am trying to share with you. This is a draft agreement between the Slovak Republic and the Holy See. Well, the Slovak Republic and the Holy See have signed a concordataриan agreement, a basic treaty, in 2000. And that's kind of an international agreement. It's very similar to the Concordat of Poland. But one of the interesting differences between the Polish Concordat and the Slovak Agreement is Article 7 of the Slovak Agreement, that is on the freedom of conscience. The English translation would read, "The Slovak Republic recognizes the right of all to obey their conscience according to the doctrinal principles and morals of the Catholic Church. The extent and conditions of the application of this right will be defined by a special accord between the Holy See and the Slovak Republic." Well, this may seem to be a contradiction in itself. Certainly, the agreement only refers for jurisdictional reasons to Catholics. The state approach would be certainly a different one. For the state, each and every citizen is the same. Each and every religious community has its social reality. Certainly, the structure of different religious communities may be very different. The Catholic Church is unique because it is a hierarchical community, and the international center of this church is a quasi-state. It is a member of the international community. It has an international legal personality, including the right to sign agreements with states, concordatarian agreements, as we would say. The Slovak agreement in 2000, the basic agreement, has foreseen 4 partial agreements. 2 of them were signed and ratified on the military chaplaincy, or chaplaincy, pastoral care of the military personnel and the police, ordinariate for those in serving in uniform. Another agreement was signed on educational issues, and the third agreement would have been the agreement on the freedom of conscience, and the fourth agreement should be one time an agreement on financial issues. The fourth agreement has never been signed or elaborated, or not so far. Maybe in another 20 years. The agreement on the freedom of conscience was drafted. Finally, it has not been ratified, so the procedure was stopped at a certain moment. It has to be noted that the Slovak government has also elaborated a parallel agreement with other denominations within Slovakia, various Protestant communities, and that agreement has not been signed either. So they are parallel agreements with other denominations and the Catholic Church. Certainly, the agreement with the Catholic Church would have been kind of an international agreement, having precedence over domestic legislation. Certainly, no precedence before the national constitution. I bring the draft agreement for 2 reasons. One of them is that it's absolutely unique, that an agreement has this type of claim or attempt to protect conscience, the freedom of conscience of Catholics. And an agreement, a concordatarian agreement, has always 2 natures. On the one hand, it is a kind of a treaty. It's an agreement, an international treaty with rights and duties. On the other hand, it's not just a legal text. It is always a kind of a theological text, because on the part of the Holy See, the actor is not just a subject of international law. It's not just a quasi-state. but it's a religious authority, and all the actions of this authority are determined by religious doctrine. Um, so it's not just a legal text, but it's also a theological text. Um, but in that case, with the draft agreement on the freedom of conscience, on conscientious objection, as it says, uh, we have a list of claims the Holy See would make, uh, where it would be visible what is required under, let us say, Catholic faith. What are the requirements we confront the state to? What do we expect from the state? Uh, what is the point when we will say that yes, if these objections are recognized, then we would say that that very state would respect the freedom of conscience. Certainly, there are fields that are changing. Uh, Probably a couple of decades ago, handling human sex cells or cloning or things like that wouldn't have been issues. It's a changing asset of issues that are the sensitive legal issues. Um, and an interesting element of the draft agreement is that it refers to the magisterium of the Catholic Church, saying that, well, what is the conscience of a Catholic uh, is finally determined by the magisterium, by the authority of the Catholic Church. Uh, Something that would be probably very strange for someone coming from a Protestant background. Um, but here we have a list in the draft agreement uh, where the right of conscientious objection should be recognized. Uh, the very first one is comes up in different constitutions as well. The possibility of conscientious objection to the military service. It has to be noted for the Hungarian history during the late decades of communism, 70s, 80s, this is a painful story. At that time, we had a national service. All male citizens were drafted to the army. And the regime has accepted, with regard to a very limited number of small religious communities, that their adherents didn't have to serve in the army. And Nazarenes could be one example. There are very few Nazarenes in the country. Uh, their young male members didn't have to uh, fulfill their national service, and they didn't have to go to jail. With regard to Catholics refusing the national service, um, the alternative was to go to prison. And the Bishops' Conference has reasoned that, well, Catholic faith as such uh, does not recognize, uh, does not require to refuse the national service. To the contrary, it's not against Catholic faith to carry arms and under given circumstances to fight for your country. But here it comes to the sensitive question that, well, in general, Catholic faith doesn't require you not to bear arms and not to serve in an army. But there can be individual Catholics or there can be communities of individual Catholics within the Catholic Church who would say that my conscience or our conscience is contradicting to making an oath that would require that under certain circumstances we would be killing other people. That is what carrying arms is about, and we refuse all kinds of violence. Here, 15 years after the collapse of the communist system, uh, the Slovak Republic would have accepted that individual Catholics, based on their Catholic conviction, could come to the decision that they don't want to serve in the military and to bear arms. Certainly, most people in our countries refusing military service wouldn't belong to the mainstream religious communities, rather to other communities, Jehovah's Witnesses, let us say, or Buddhists. But a member of a mainstream religious community could also come to the decision, conscientious decision, not to perform military service. The sensitive field, the truly very sensitive field, where conscious objection could come up, is in the healthcare area. And here the list begins from abortion. Well, not to be compelled to take part in delivering abortion services as a medical doctor or a healthcare personnel is also recognized by positive Hungarian law. But you could have another list of sensitive issues, artificial or assisted fertilization, experimenting with human organs or embryos, uh, euthanasia, cloning, sterilization, or contraception. Well, let me stop for a moment at the very last element of the list. Uh, uh, a few years ago, we had an interesting case on a pharmacy where the pharmacy didn't want to sell contraceptives, and the claim was based on the individual Catholic conviction of the owner uh, of the of the pharmacy. Um, and it was a very interesting debate whether people, well, possible clients, uh, have the right to buy contraceptives in any pharmacy as long as contraceptives are legal, or we should rather respect the position of this private business. Um, the owner of the pharmacy, uh, for the sake of his conviction, uh, has accepted that his revenues will be cut by this, will be reduced by this decision. It's he pays for his conviction. He's ready to pay for it, and that itself is an interesting element, is an interesting factor when we are balancing competing rights and interests. It's But the draft treaty on the freedom of conscience's objection between the Slovak Republic and the Holy See uh, would have probably accepted this claim that, well, I don't even want to touch it. It is against my conscience. Then education, Article 12 and 13 of the Basic Treaty refer to parental rights and religious education. legal services, provision of legal services. Well, do I have to, as a running an individual legal business, do I have to work on divorce issues more sensitively? As a judge, do I have to take part in divorce cases? I assume that it wouldn't refer to the latter one because that's not a legal service in a service providing sense, but it's under the authority of the state. But it's an interesting question whether a Catholic can take part in divorce issues, and how far this participation can be limited if we have a right to opt out from these issues. And the last element of individual aspects would be labor law issues that, based on the conscience of the individual, you should have, as an individual employee, you should have the right to refuse certain actions. Certainly, the particular element of this structure is that in these cases, what has been foreseen was that an individual Catholic is refusing to do something, to take part in something, and he or she is referring to his Catholic faith. And what is Catholic faith is defined by the magisterium of the Catholic Church. So it's not the traditional, very individualized concept of conscience. And the second part of claims would be on institutional aspects, particularly on hospitals and healthcare facilities maintained by the Catholic Church, a Catholic organization, that these institutions by no chance should be compelled to handle against, well, the above mentioned, I would even say, traditional list or activities that are clearly contrary to Catholic moral doctrines. As said before, I think that it's very interesting to see that we can have a kind of a normative list and of conscience claims. Of course, by nature, conscience can never be 100% subject of a normative list. It is always blowing it up. It is always but it has to be by nature always broader, and we can never come to the end of the list. But there is still a but. I think that this attempt of make a list of requirements, what we expect from the state, what is the list of our expectations, is very, very interesting. And although the Slovak Republic is neither Poland nor Hungary, the issues coming up could be issues that would be relevant in all over the world. I mean, certainly when the Catholic Church is fighting for the liberty of conscience of of its members, then Catholics have a seemingly easy way out. It's enough to say that, well, I don't do that because I'm a Catholic, and and basta, and that's it. But by nature of conscience, we always have to treasure individuals who are ready to fight for their individual conviction and their individual conscience. I think even if some of these people may look a bit weird or may sound a bit weird sometimes, I think we have to cherish them and recognize their claims, their fight, as long as they are well-founded and serious. Thank you for your attention.
Thank you very much for the very interesting presentation. I'm jealous of you because your topics are much more interesting than mine. I would have lots of questions. For a couple of minutes, Zdzislaw joined us, but perhaps the Hungarian supermajority threatened him. So I think it's my part now. I'd like to be very brief and put some questions, and then I'd love to have some discussion because I may have some questions for both of you. First, let's start with my presentation, just to give evidence that I did work. So hopefully now you see my slides. Do you? If you are mute, you cannot answer. But...
We do.
Okay. Just a second. I'm not really talented. Okay. So last time, my presentation was about conscience itself and try to make a map on the questions. And now I move to the other part, how it can be institutionalized. What about collective conscience? And if we start with the evaluation of human rights, we see that from the French Revolution, from the Enlightenment, basically individuals have fundamental rights. Right to property, right to life, and non-discrimination and everything. And the states were bound by human rights, so it was a restriction for state activity. In some parts of life, the states have to be non-active, so just to remain, keep out of our private sphere, not to take our property, not to take our lives, and so on. In some other rights, the state had to be active and actively promote the performance of the fundamental right. Not long after, we will realize that there's a necessity for the fundamental rights for private law entities. Companies may also have the freedom of enterprise, the right to property, and so on. And of course, there's a differentiation. Private law entities can have rights that are in accordance with their nature. So companies do not have religion, they do not have life. So therefore, they can't have such rights. But all rights that are in accordance with their nature, they are also possessors of rights. Another step of the evaluation was that communities may also have rights, not just individuals. The best example might be the freedom, the right for a healthy environment. Environment is a common value. We can't say that your environment is healthy, but mine is not, as we live in the same nature, in the same environment. This is a community right. One next question is that it's not just the state, but it's also private law entities who are bound by fundamental rights. So individuals may have rights against private law entities. One contemporary example is, what if Facebook restricts my freedom of expression by not granting me the possibility for sharing some contents? The question is if it is possible or not, but it is entirely possible that private law entities may restrict individual rights. And one last step is that states may have also rights against itself. You do know the Constitutional Court jurisprudence acknowledging the fundamental rights of states. So what about the freedom of conscience? Freedom of conscience is basically an individual right. At first glance, we would say that it closely connects for closely connects to dignity. It's close to our human nature that we have a conscience. Companies don't have conscience. Associations don't have conscience either. However, there is a possibility for institutionalizing conscience, religion is pretty much the same. Individuals have religions, but under some criteria, associations like churches can also refer to their freedom of religion. So it's not just an individual right. There is a possibility for institutionalizing conscience. But how? The next question is, if conscience is an institutional right or a collective right. If it is institutional, it means that the institution itself has the right to conscience. If it is a collective right, in the latter case, it's not the institution, but the members of the community. The people who are in the institution have the conscience. And it does make a serious difference between the two. The first question, who decides the content of conscience? What is the conscience? Balázs had the example with the pharmacy. Is it the owner of the pharmacy, or is it the founder of the pharmacy who decides not selling birth control pills? Or is it the pharmacists themselves who can decide? And obviously, the two may vary. If freedom of conscience is an institutional right, then it is the founder, the owner, it is one person. And if it is the collective, then the community themselves decides. It leads us to another question. Let's say that the owner of the pharmacy is the one who has the right. Then it is rather stable. Let's say the founding documents of the pharmacy stipulates the biased nature of the pharmacy, and according to their conscience, it is they don't sell birth control pills. Then it is rather stable. On the contrary, if it is the community who has the right, then The pharmacists themselves may vary. Let's say some leave the job, some new people enter to the pharmacy, and they have a different conscience, which means that at times to time vary, they are ready to sell such products, unlike if it is the owner who decides, and it is stipulated in the founding documents. And one other question in this sense, that what if the individual conscience conflicts the institutional one? In the pharmacy example, what if there is a pharmacist who is really keen on for feminist movements and says that it's everyone's right to decide either having a baby or not, and this pharmacist is ready for selling birth control pills or even after pills. But what if it is against the nature of that particular pharmacy? If it is an institutional right, I would say, then this pharmacist shouldn't work there, because the conscience of the institution is against the personal conscience, and this conflict cannot be eased. Therefore, the institutional conscience may overrule the individual. On the contrary, if it is the community who has the conscience, it means that it may change, and the personal conscience may overrule the collective conscience. Anyway, either we consider conscience an institutional or a collective freedom, it is always a derivative one, so it derives from personal conscience, because conscience by nature is for human beings. The question is how to settle the cases. Last time I had only questions. Now I have more questions than answers, but also trying to give some answers. Now I see two options. One possibility is that it is the legislation who should ease the tension, who should solve the conflicts. In this case, the legislator, it's mostly a political job to sum up the most frequent cases of collision. Adam's example with the public servants, Balázs' example with the pharmacists, but we can also have examples from healthcare, education, and so on and so on. And the task of the legislator is to sum up the cases, and by law, they should decide what to do in such situation, which means that from that on, it's a piece of legislation, it's an act of parliament that decide if there is a possibility for objection by conscience in the particular case. And the law says that in some cases you do have this possibility, in some others you don't. And from that on, it's not a constitutional possibility, but a statutory one. It is granted by the law and not by the conscience, not by the constitution. Obviously, the law itself must be in accordance with the constitution, but if the law in general is in line with the constitution, then individuals can only rely on the law and not the constitution as a fundamental right. The second possibility is the jurisdiction. There is a general test for conscience. So the law shouldn't discover all cases of conflicts or the most frequent cases of conflicts, but there is a general test. And if I meet the criteria, then I can rely on conscience. I can code for a conscience objection. And in the particular case, irrespective of the legislation, the objection is granted. The question is, who do you trust more, legislation or jurisdiction? I personally more rely on jurisdiction than legislation, but I acknowledge that both answers are valid. And I need to admit that it is much more simple to rely on the legislation and to sum up the most frequent cases of collision. By now, I see it quite unlikely that you can have a general test valid for all cases of conflicts. This is the harder way to go, but still there should be some general clues also for judges to be in line with freedom of conscience. All in all, I don't want to lose freedom of conscience as a constitutional right. I'm not really friendly with the idea that it's just the legislation to sum up the cases of collision. But so far, I see this the easier way to go. So thank you for your attendance. I try to get back to you. Have I stopped sharing screen? I think I have. Okay. Question time. We spoke almost exactly the same time as last with 6 people. So we are very talkative, and I really like it. Can I start with the questions? It's misusing power of a team leader, but I forget. Well, I have some notes. As for the presentation of Adam about the public servant's conscience, I think we can agree that the personal freedom of conscience is equal to everyone. There shouldn't be any difference by the fundamental right itself. This means that in the case of public servants, there is a stronger legitimate aim for restriction. So the fundamental right is equal, but there is a stronger need for restriction, if I'm correct. But if you accept this statement, then it leads to another question. Is it the nature of the work, or is it the person of the employer that decides the restriction? I mean that even if it is, you say that public servants have, there are more reasons to restrict the conscience in this sense. Let's say that I'm a school teacher teaching biology, but I'm not really willing to teach evolution, as I consider that God created the earth and all species and mankind. Does it matter that I'm a teacher of a state-run school, a school of a foundation, not being a public employer, a public servant, or a teacher of a religious school, a Catholic school, who perhaps oblige me not to teach evolution? So how would you differ the three? Because my activity is the same. I'm a school teacher teaching biology. So And there's another question. Both of you had the issue. I'm wondering if conscience is necessarily religious or not. Mostly we speak of religious conscience, but I'm wondering if there's a constitutional argument for conscience being purely religious. From that on, I will explain my. And this leads to Blair's question. Obviously, if there's an international agreement between a country and the Holy See, it is about Catholics. Why would they consider others? Doesn't it result that it excludes others, not only non-Catholic believers, but only non-religious conscience? And back to the pharmacy issue, I'm wondering if it is a difference between if it is an after pill or a birth control pill. Because birth control pill is for the future, you can buy it anywhere, and you can check the next pharmacy. But if it is an after pill, you need it urgent. And you can't, you may not have the time to go to the next pharmacy. So the outcome of performing individual conscience is different in the two cases. So I'm looking for your answers, and thank you.
Thank you, Laurent. To your first question, when you had become a teacher, you had to take into account that there are legal and also professional limits or standards, and I within your certain example, I do not see real contradictions, because it's allowed in all types of schools to at least mention that there are two different theories related to the creation of the world. It's for me, it's not a real question of consciousness or something like that.
It's quite interesting. As I'm not an expert of the issue, but in America, you can say that there's a competing idea for evolution: intelligent planning. You cannot say that God created, but there was an intelligent planning, which is, on the one hand, this is true, but on the one hand, it doesn't show the anti-truth. So I think there is still some issues. Okay. What if non-religious conscience? What about non-religious conscience?
I had no problem with that. To the contrary, it's maybe I had two different points on that. One is that we don't want to end up in a situation when you only have the right to things that are provided to you, because then you don't have fundamental rights. So sometimes, of course, when there are typical claims and a significant number of claims arise, then it's reasonable to make a structure for it. How you apply for civil alternative service to the military. And you don't handle each and every case individually, but you have a form and you fill it in and you sign it, and that's it. But by nature of conscience, we have to leave the alternative way that, well, an individual gets up in the morning and says that, well, I have a special claim no one else has raised before, and the state probably jurisprudence, as you have said, has to react on it. And one specific feature of the Hungarian ecclesiastical, as we would say, so the legal regulation of church and state relations, is that our regulation, when possible, is very, very individualistic, and it's not taking the membership of an individual into account, but the individual decision. Uh, One example could be the funding of religious communities via the tax assignment system. It's not an automatic system that the taxation authority would know your adherence, uh, uh, I don't know, baptism record, and you have to pay as a membership fee. But you can have a different decision each and every year, and you can support a religious community you don't belong to. Many people, I think, do. Um it's an individual decision, or the participation in religious education at school is the decision of the parents. They don't even have to be members of the given community. You can go to an alternative education or the religious education of another religious community. It's the individual decision, and the same applies to uh, in the given case. We hope the case will never come, but the same would apply to the conscientious objection to the military. It's uh, it's not enough to say that I'm a Jehovah's Witness. Uh, you have to say that, well, it's against my conscience. And whether your conscience is determined by a specific concept of pacifism, or by the membership in with Jehovah's Witnesses, it doesn't matter. And even more probably, it would be better for the state not even to recognize or take into consideration memberships in religious communities. It's not the business for the state. Um, but it's in each and every case when conscience is invoked, it is the individual vis-a-vis the state, or in the Drittwirkung cases you have mentioned, Laura, before, it may not be the state anymore, but an employer or whoever. Uh, but it's in any case, it's the individual, and and I would argue that he or she had to invoke his or her individual conscience, and that conscience may be formed or educated, maybe in a religious tradition or a religious community, but it could have any other background or reasoning, um, as long as it is a conviction and not merely not merely just a preference, uh, not merely a question of taste, um, but someone has a strong conviction, um, and of course uh, they would be tempted to say that, well, religious convictions are by their nature strong and firm, and but probably for many people, even religion, they feel a kind of a belonging, but it's a vague concept, they don't even have to be very coherent in their everyday life. Um some people, probably, I hope they are, but many people are not, and we have to have a kind of an understanding for these people who have preferences or vague belongings. But when it comes to conscience, I would say that, well, conscience is about something solid, something where there is a conviction behind, and that conviction can be of different natures, but it has to be a conviction.
Yes. If I put the question, if conscience is more valuable if there are many sharing the same faith, politically, yes, because the legislator considers the many. If there are many people having the same problem, politically, you need to deal something with it. If we consider it from a fundamental right perspective, the answer is definitely no. But still, I think this is a reason why you need to consider both the legislative and the judicial approach. Okay, any questions?
Yes. May I add something?
Sure.
Oh, thank you. There is always a high tradition, which is the textualist legal interpretation of the given religion developed by the certain church. And distinct from this, there is also a so-called little tradition or lived tradition, which is the lived religiosity of individuals or families or even communities. How should authorities react if there is a huge gap between those two viewpoints, but both claim to belong to the same religion or church, for example, to the Catholic Church or Catholic viewpoint? Who shall decide in a case of a conscientious objection which one is the correct, or who should make a statement that both can be followed? Maybe the authority or the hospital should ask for an expert opinion from the Catholic Church. In your case, Balázs, maybe not. What will happen in a certain case in Slovakia if the treaty will be signed?
Balázs?
Yeah, of course, my Slovak friends don't believe in the treaty being signed, but the text is still there, and the text was agreed upon by a government and the OEC, so it has some relevance. I think that when the sensitivity for a right is growing, then it's beneficial generally. And it has its spin-off effects for people who don't belong to that very community. Because the awareness, the sensitivity of the right is expanding. And of course, you may have the feeling when you look at this text that it is well just about Catholics, devout Catholics, Catholics who follow church doctrine in their way of life, etc. But it's but it has a by nature when a state is not extremely biased, then it may have it should have the consequence that generally the acceptance of conscientious claims is growing, is raising. And in a, I'm afraid that we are living in a society that is where we are not used to have conscientious claims or religious claims either. People are just shy on this issue, and they wouldn't speak about it at their workplace or at the public school, etc. It's in their private, so they would avoid conflicts. Probably the legacy of the communist era is still with us, but it could also have other historic or social reasons. So I think that when some people come up with their claims, then this could help other people to come up with their similar claims as well. Um, and if some claims get backwind, get some support, then this could have its spin-off effects to other claims as well.
If I'm ahead, it's an interesting question. To what extent does your church influence your personal view? Catholics may easily say, of course it does. Protestants would disagree, and it says, no, it's my personal conviction, and my personal conviction influence the church because we ourselves decide our standpoint. So my answer to your question, Adam, is quite simple. The standpoint of the church is perfectly irrelevant. I don't care their standpoint because it's my conscience. And my conscience is not strongly connected to the standpoint of the church in one particular issue. And that was the case in vaccination, that one argument against objection by conscience was that none of the mainstream communities disagree with vaccination. But I don't care because it's not, they cannot form the personal conscience.
The expression we use is that under certain circumstances, of course, conscience is very individual for a Catholic as well. No question about it, because it's God's voice in your very person. But you are expected to bend your conscience. So it's
That's the basic difference between us.
yes, that's the difference.
Any other questions? Okay, then it was really nice discussing issues, and as there weren't too many of us, we had more time for discussions. I promote such kinds of discussions. So thank you for your attendance, and obviously I see you time to time, but officially we see each other some 14th of July in the morning, 9 a.m. Okay, thank you, goodbye.
Thank you, Laura.